5 seconds to go. Start. The Council for the Appellants had specifically submitted that respondent number 2 had shown no inclination to re-establish any relationship with her children. A mere reference to the names of family members in a criminal case arising out of a matrimonial dispute without specific allegations indicating their active involvement should be nipped in the bud. It is a well recognized fact born out of judicial experience that there is often a tendency to implicate all the members of the husband's family when domestic disputes arise out of a matrimonial discord. Such generalized and sweeping accusations, unsupported by concrete evidence or particularized allegations, cannot form the basis for criminal prosecution. Courts must exercise caution in such cases to prevent misuse of legal provisions and the legal process and avoid unnecessary harassment of innocent family members. In the present case, appellant numbers 2 to 6, who are the members of the family of appellant number 1, have been living in different cities and have not resided in the matrimonial house of appellant number 1 and respondent number 2 herein. Hence, they cannot be dragged into criminal prosecution, and the same would be an abuse of the process of the law in the absence of specific allegations made against each of them. The facts in the said case are of similar nature when compared to the present case. It was held by this court that vague allegations of cruelty were levelled by the complainant therein wife and the relatives of the husband, including the parents in law, were dragged into the crime without any reason. In paragraphs 18 and 21, it was held that the contents of the FIR were vague and omnibus, that the FIR lacked precise allegations, and it was lodged after the legal notice for divorce was sent by the complainant therein. It was therefore concluded that the FIR came to be lodged as a retaliatory measure intended to settle score with the husband and his relatives. In another recent judgment of this court titled Jai Deep Singh and others versus State of Gujarat, the guilt of the appellant therein under section 498A of IPC was maintained. However, the ingredients of 498A of IPC were discussed. It was observed thus: from the above understanding of the provision, it is evident that cruelty simpliciter is not enough to constitute the offence. Rather, it must be done either with the intention to cause grave injury or to drive her to commit suicide, or with intention to coercing her or her relatives to meet unlawful demands. Hence, it was clear that cruelty is not enough to constitute the offence. It must be done with the intention to cause grave injury or drive the victim to commit suicide or inflict grave injury to herself. In the present case, the allegations levelled in the FIR do not reveal the existence of any such allegations. The only allegation that referred to an injury being inflicted against the complainant is a vague statement that the son of the appellants herein used to beat her, but there is no specific allegation of any such injury being caused by the appellants herein. In the present case, in the later half of the FIR, it is alleged that the complainant was given poisonous food by the appellants herein and was coerced into consuming the same. This led to the miscarriage, and therefore the offences under sections 312 and 313 of IPC were attracted. Sections 312 and 313 of the IPC read as under: whoever voluntarily causes a woman with a child to miscarry shall, if such miscarriage be not caused in good faith for the purpose of saving the life of the woman, be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both, and if the woman be quick with child, shall be punished with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine. A woman who causes herself to miscarry is within the meaning of this section. Whoever commits the offence defined in the last preceding section without the consent of the woman, whether the woman is quick with the child or not, shall be punished with 349 imprisonment for life, or with imprisonment of either description for a term which may extend to 10 years, and shall also be liable to fine. From a perusal of the provisions, it is clear that the ingredients necessary for the offence under section 312 of the IPC is that the miscarriage must be voluntarily caused and must not be caused in good faith for the purpose of saving the life of the woman. Section 313 of the IPC states that the offence is attracted if the offence under section 312 of the IPC is done without the consent of the women. The presence of the ingredients of the offences under sections 312 and 313 of the IPC may be further examined through the perusal of the charge sheet dated 8 February 2021. The statement given by the doctor who treated the complainant after the alleged incident on 28 November 2016 is found in the charge sheet. Same is reproduced herein below. The complainant in this case, Pushpa Madhav Suryavanshi, came to our hospital on 5th December 2016 at 2:30 p.m. in the OPD for treatment of a complaint of abdominal pain and bleeding. I would have questioned the woman after enrolling in the OPD. She told me that she was diagnosed with pregnancy when her urine was tested 7 days before coming to the hospital. But she told me that the next day, after I was examined by Kit, she told me that the abortion pills must have been in my stomach. Having told me that, I examined her and did sonography. While doing this sonography, I noticed that she had a 7-week-old lifeless fetus in her womb and was bleeding. Also, the blood in her body was very low. There was a great deal of abdominal pain as the lifeless fetus in the womb. So I admitted her for further treatment at 5 o'clock that evening. I then injected her with sleep and surgically removed the lifeless fetus by suction and evacuation. And then I discharged her after further treatment and the next day with a sonography to make sure the fetus was completely gone, and sent her home. Due to the abortion pill was given to the woman and her fetus became lifeless, and because of the previous 2 cesareans, the abortion was not completed at home. Her excessive bleeding had reduced the amount of blood in her body. Later, she came to my hospital for treatment as she was suffering from severe abdominal pain and bleeding. While she was admitted in our hospital, she was accompanied by Sandhya Rathod. She was signed our documents. However, Pushpa Madhav Suryavanshi was in my hospital on 5th December 2016 when she was 7 weeks pregnant and she was bleeding and having abdominal pain. Her sonography showed that her fetus became lifeless as abortion pill had been inserted into her abdomen. I have treated her with suction and evacuation. Stop.